Hello, everybody.
I think I can hear you just fine. Can you hear me?
I can, thank you. So the court is on the record in the matter of People versus Nathan James McElroy. This is file number 24-4966 on page.
Brian Ziegler again.
Kyle Travis on behalf of Mr. McElroy.
Thank you. So Mr. McElroy, as you know, we're here for a couple of different things today. We had a status conference a few months ago where you had asked for trial. So I set this case for what's called a final status conference and a plea cutoff for today's date. And to the extent we need it, we have trial set on March 11th for your benefit. Do you understand all that background?
Yes, sir.
And since the last time we met in court, have you had a chance to stay in good contact with your attorney?
Yeah. As a matter of fact, we've had pretty good contact. And
All
just
right.
got them talking.
And so the question I'll ultimately have for you is whether or not you've been informed of any plea offer, and then whether or not you wanted to take advantage of them. As you know, a plea cutoff means after today, I won't accept any further plea offers. We'll just have the jury determine the issues. Are you aware of that background?
Yes, I am.
All right,
And Your Honor,
Mr. Travis.
if I could interject, I actually just called and talked to Mr. McElroy about something that I talked with Mr. Ziegler and Mr. Seeger about. One of the two alleged victims in this case, I thought I might have had a conflict with. I did just a search through my computer, didn't see it, said, that's kind of funny. I thought I recognized that name. Yesterday afternoon, actually just doing some housekeeping in the office and cleaning up some old emails, I did come across the fact that I did represent him on a certain type of file and believe there is a conflict, and have talked to Mr. Seeger about that. And
Well, if there's a conflict and you can't be on the case, and you can't be on the case, but we're a month before trial. How is it that you just determined that you had a conflict because you represented one of the victims 30 days before trial?
as I was saying, Your Honor, I usually make every person a file in my computer. And so when I went to look, I looked and couldn't find a file on him. I was deleting emails because the email account can only hold so much just as a housekeeping thing, and actually came across some emails. And there's one, obviously it's my fault, but two, given the nature of the thing I represented him on and the time period in which I represented him on, I think that's part of why I didn't create a file. And that was my error, to assume a check of my files would tell me if I represented him.
So the bigger question that I have is, assuming I find good cause and find that it's appropriate that you can't represent Mr. McElroy, how are you going to have your system fixed so that this type of issue doesn't come up, number one, really at all, but if it does come up, it comes up early in a case when you're first assigned, so you can screen and make sure that you can handle the matter?
There's actually got me thinking about two things. That particular type of one, I don't generally take those kind of appointments anymore. The reason I'm being kind of, and I could approach and explain it to you, but I'm not sure that I can.
There's ethical issues with you.
I can say what type of representation I did, because I don't know if it's a public record.
Well, let me ask it this way. Your remembrance of what you had represented this other claimed witness or claimed victim in, you believe it would give you information about that witness that you could use against that witness, and is that what you're concerned about?
That is correct.
All right. So, Mr. Ziegler, were you made aware of this background?
I was made aware of it today, Your Honor.
Did you have a response to it?
I don't have a particular response to it, Your Honor. I think I recall Mr. Travis and I having a discussion about having represented Mr. Mandel on another matter earlier on in the case, and he wasn't able to find anything. I hadn't really given it any further thought until it was brought up again today. I'm aware of what the nature of the prior representation is. And I would agree that if Mr. Travis represented him on that kind of matter in the past, it would definitely be a conflict for trial.
Because of what he learned in the context of that representation as it relates to questions he might ask of the alleged victim?
I would believe so, Your Honor. Obviously, I don't know exactly what they discussed, but given the nature of the representation, yes.
Mr. McElroy, were you able to hear all of that discussion so far?
Yeah, I was just wondering if the conflict of interest, I mean, does that make him inadequate to be able to represent me in something that's happened in the past? Or that he would just
Well,
have an inside look at this person, know who they were and who he's up against?
Yeah, that's a fair question, but here's how generally the rules of ethics require action is number one, once known about your attorney, Mr. Travis has a duty of disclosure. He has to disclose the potential conflict to me. And then the laws and the rules regarding ethics require me to make a determination whether or not he is going to be conflicted. That is, whether or not I release him from being able to represent you. But you have a right to be heard on that as well, meaning if you wanted to be heard, I'd let you state your case. But generally speaking, the determination of whether or not there's an ethical conflict is first from the attorney who's involved with it. And then I have to make a determination based upon what's been reported by the attorney, whether or not I believe there's a potential conflict. So did you want to be heard? It sounds like your attorney is saying he believes he would have a conflict. Certain things he came across in his prior representation would make him unable to ask the questions that he may need to ask in representing you. Is that how you heard him?
Yeah, I suppose you could say it was something like that. Yeah. So
Also, what's your response, Mr. McElroy?
well, I mean, he's got to do what he's got to do, you know. I would have to say if I was in his position, I'd have to keep it at a professional level and set one thing aside from the other. But I can't say as to how his mind works and what's ethically great for him or not. So I guess it is what it is. Move forward.
All right. So, Mr. Chavez, I haven't heard a specific request by you yet, but implicit in your disclosure to the court is you don't believe you can proceed as counsel for Mr. McElroy. Is that right?
That is correct, Your Honor.
So you're asking to be relieved because of your ethical obligations to both clients, but more specifically to your prior client.
Well, correct, Your Honor. I believe because of my obligation to him, I may not be able to properly serve Mr. McElroy.
Anything further from the prosecution before I decide how to proceed?
Just that given the nature of the prior representation and the questions that I think are going to need to be asked at trial, I would support Mr. Travis's request to withdraw.
So, Mr. McElroy, I appreciate your insight in this case, and that is, you're right. Ordinarily, we want attorneys to be able to act in a way that they set aside one case to deal primarily with the one in front of them. On the other hand, attorneys are bound by various ethical rules, and I'm bound by various ethical rules as well. Meaning Mr. Travis was willing to discuss more about the background with me, but I declined to hear from him in that regard because the sacrosanct nature of his relationship with Mr. Mandela and that with you requires that I'm not asking questions about the independent conversations that you have with Mr. Travis or that Mr. Travis had with Mr. Mandela. I'm not entitled to know those things. In other words, because the attorney-client privilege is so strong. Because of that, ordinarily, courts are expected to accept attorneys at their word when attorneys on the open court record expose that they have a conflict. I wish that this conflict would have came to light earlier because we're now, as I started with, talking to Mr. Travis a month before trial. I'm certain that Mr. Travis wishes this would have come to light earlier as well, because delays in this case, like delays in any case, can be bad not only for you, but also for the prosecution. But it is the way that it has come about, I don't find to be in bad faith. I don't blame you, Mr. Travis. I hope that there's a way you can figure out a way to not have this conflict come up so late in the game, but I don't have any reason to do anything other than accept your statements today. So I'm going to allow you to withdraw under the ethical rules. You're going to need to prepare an order that says, I'm going to allow you to withdraw based upon your request of a cited conflict. Mr. McElroy, that necessarily means that because I'm allowing Mr. Travis to be removed, the question next comes to you. My understanding is Mr. Travis has been appointed to represent you, correct?
Yes, sir.
And so is it your view that so long as circumstances hasn't changed with Mr. McElroy, you would just submit it back to Mr. Seeger through the MIDC to have appointment of a different attorney?
Your Honor, I've actually got a substitution. When I called Mr. Seeger this morning, he reached out to Mr. Horowitz. Mr. Horowitz emailed me with permission to sign the substitution to counsel.
Okay, and the substitution's fine, but I still need an order that grants your request to be withdrawn because of the conflict.
Okay.
I think I view that as important as a substitution. Obviously, we need a new attorney. Mr. Seeger, is that accurate as MIDC coordinator?
Exactly. Yeah.
Okay. Anything further you wanted to weigh in on from MIDC side since we're all here?
No, Your Honor.
Mr. McElroy, do you know Attorney Horowitz?
No, I don't. I've had most of my dealings with Mr. Seeger, Kyle Travis there. Other than the lawyers that I know in my personal life out here, which I would rather have represent me in a situation like this. But I guess Mr. Horowitz will have to work, you know.
Well, you always have the choice of counsel, Mr. McElroy, if you choose to hire an attorney, but you don't have that choice if you seek court-appointed counsel. I know you were happy, it sounds like, with Mr. Travis, but for reasons already stated, I'm going to release him. So Mr. Horowitz is going to be your attorney. You need to get in communication with him very soon. Mr. Seeger, do you happen to have a number that I can provide Mr. McElroy?
There might even be a card up there, Your Honor, but I mean.
Let me see if there is. Mr. McElroy, do you have something to write with?
Yes, I do. I just set it down. With that pen. Yeah. Oh, there's another one. Thank you.
Okay, let me know once you get it.
Did you find a number up there? Your Honor?
Oh, here we go.
Thank you. So counsel, you can approach with that substitution, at least we'll get that and then follow up. Are you ready?
Yes, sir.
Okay, his name is Michael Horowitz. Thank you. And his last name is Horowitz. And his phone number is 231. Did you get that number?
Okay. Yes, sir.
So necessarily, Mr. McElroy, I'm sorry, go ahead.
Oh, it's 231.
That's it. So, Mr. McElroy, necessarily what that means from my perspective, at least, is I need to give you time to minimally reach out and contact Mr. McElroy, Mr. Horowitz, and for him time to get up to speed to decide how he and you want to proceed on this case. I know that you would rather have proceeded in a different fashion, but now that I've decided to allow Mr. Horowitz to substitute in to represent you, do you want to be heard on that plan by the court?
Oh, I mean, you know, I've known Mr. Seeger and Mr. Travis for probably 10 years now. And I mean, I can't replace that time with this guy that I've never met before. So, I mean, I have to show him that I'm worth fighting for, I guess, on my own level.
Sure. Well, what I plan to do is bring you back. What I plan to do is bring you back in about 60 days. That will give you at least that couple month time period to discuss in full with Mr. Horowitz, get comfortable with him and he with you, and then have a plan. If you simply need to set it for a new trial date, we'll set it for a new trial date. But I want to give Mr. Horowitz the time to get up to speed. So do you have an opposition to that time period?
No, can I get the 10 years that I got with these other two back? Yeah, no, it'll work. No.
I didn't catch what your question was.
Yeah, I'll be all right with it. I mean, got to go with it. So, yeah.
Well, you don't have to if you have a different alternative suggestion, but I also heard a question, but I didn't catch what it was. Did you have a question for the court?
I kind of want, I mean, it doesn't have to be answered right now. We can still come back in 60 days, but I mean, due to the nature of the things, I really love to just, oh, my phone died. Are you still there? I lost it.
You're still there, but you're not via video any longer. I'm breaking up for a second. Go ahead with your question if you have one.
I don't.
So the court would note that I'm going to set a status conference in 60 days. First, on behalf of people, do you have an opposition to that given the circumstances? No, Your Honor. I'm going to take down the trial on March 11th. It's way too soon for Mr. Horowitz to be able to sub in as confident as I know he is as an attorney. That's too short of a time, given the felony nature of these charges. So I'll set a status conference in 60 days to discuss with the two attorneys and hopefully Mr. McElroy again. I waive any disconnection issue on his behalf. He was here for the hearing. He had a question. I don't know what it was, but in any event, if he has questions in the future, I'll cover those with him. The court will be in recess on this case.
I couldn't imagine any other life. Spending it with you guys is the best. Be safe, be well, sleep sweet, and much love.